My name is Jennifer Monteroso, and I am the managing attorney of the housing team with Legal Aid Society of San Diego. And we are here today to talk to you a little bit about the County of San Diego residential eviction ban, which is the moratorium that went into effect after the floods earlier this year, and also give you some important updates on the Tenant Protection Act, because those two working together are going to be important for citizens in San Diego to be aware of. So as always, we have to let you know that this program and presentation is funded by the County of San Diego, so we are grateful for the county for being able to put on presentations like this. So the first thing that we want to talk about is the County of San Diego's residential eviction ban. And so essentially, as we all know, there was the historic flooding in San Diego on January 22nd. And that was a once in a century rain that caused a lot of destruction and caused a lot of displacement of tenants throughout the County of San Diego. And so in order to address this unique situation, the Board of Supervisors for the county implemented what we're referring to as a eviction ban or an eviction moratorium, which essentially put a pause on a landlord's ability to evict a tenant if they were impacted by the flood. And so under the county ban, essentially those people who were protected by this ban were essentially those who lived in a flood-affected zip code. And we have here on the slide for you a list of all of the zip codes that were identified by the county. And in addition to being in a flood-affected zone, the individual or individuals had to also have suffered economic loss. And so when we're talking about economic loss, it's a really broad definition, and it could include anything such as reduced income, increased expenses, or any other sort of economic consequence that was either directly or indirectly caused by the flood. So some of the examples we have been able to identify are lost work hours. So if you were unable to work because you couldn't get to work or because your business was flooded, that would be something that qualifies as an economic loss. If there was damage to your property or to your unit, or you had to move because there was damage to your unit or building, that would also qualify. It includes any loss that is caused by a landlord also in the course of improperly evicting or requiring a tenant to relocate. So we're going to get into the specifics of what the moratorium prevented, but essentially if a landlord was violating the moratorium, then any economic loss that the tenant was impacted by would qualify to protect them under the moratorium. So one of the questions that we get asked a lot is, if I suffered economic loss and I live in a flood-affected area, is the landlord allowed to evict me because my unit was damaged by the rain or flood? And so the short answer is no. Under the ordinance, a landlord could not terminate a tenancy without what we call just cause, meaning a legitimate reason to evict the tenant. And so in addition to requiring just cause, there are also certain behaviors and things that landlords were prohibited from doing. So one of those is serving a notice of termination on a tenant who the landlord knows or should have known that they suffered economic loss caused by the flood. So that means that a landlord was prevented from giving a tenant a notice after January 22nd saying, okay, we're evicting you, you have to go. And that's again if the landlord knows or should have known that the person suffered economic loss from the flood. And usually if you were living in a flood-affected zip code, it was very likely that the landlord is aware that the flood happened and their property may have been impacted. Another thing that landlords are prohibited from doing is filing or serving an unlawful detainer lawsuit. Also includes a few other actions, but the unlawful detainer is probably the most common, and it is what we commonly refer to as an eviction. But unlawful detainer is the legal term for the court case to lawfully remove someone from a property. So under the moratorium, landlords could not serve that type of lawsuit or otherwise use a legal mechanism to remove the client from or remove the tenant from the home. Also, they're prevented from evicting a tenant or requiring the tenant to vacate the unit, including by seeking the entry of an eviction judgment or causing or permitting a writ of possession to be executed. So along the lines of what I just mentioned with the legal case, the unlawful detainer, essentially as part of the legal process of an eviction, a landlord, if they win at the unlawful detainer stage, they usually get what's called a writ of possession. And that gives them legal title to the property, and ultimately that's what they present to the sheriff's office for the sheriff to come and complete the eviction cycle. And so under the moratorium, a landlord was not able to move forward and actually remove someone from the property under what is traditionally legal mechanisms by either A, asking the sheriff to actually execute that writ of possession, or by trying to look for or obtain a judgment, a legal judgment against the tenant. Another thing is they can't take any other action in reliance of a notice of termination of the tenancy that expired, or try and get the tenant to vacate based on that type of notice. So again, as we mentioned, landlords cannot serve notices telling the tenant you have to leave from January 22nd through the end of this moratorium, which is March 30th, and they can't take any other action trying to rely on that notice. And one of the important things that we see, which is one of the last items that a landlord cannot do, is try and represent to the tenant that they have to leave the unit. And so we have had the situation come up where we have had landlords telling tenants, well, legally you have to go, so you need to leave. That is something that is expressly prohibited by the moratorium. All right, so another question that we get asked is, if I have to leave my home in order for the landlord to make repairs, who's responsible for my alternative housing and hotel? So the answer to this question is, it depends kind of answer. So generally, if you have paid your rent and you are unable to live in your home because it is not habitable, meaning that it's not safe for humans to be there, then that is a circumstance where the landlord would be required to provide some sort of alternative housing. And that's because you have paid your rent, you have paid for the use of the property, but you are unable to use it due to these circumstances. And so generally, in that scenario, a landlord would usually be responsible for paying your hotel. In the event that you have not paid your rent, then ultimately it is not necessarily the landlord's responsibility to cover any hotel expenses or alternative housing. Now, you can certainly discuss with your landlord, reach an agreement, because if you're not paying rent, and you can't live in the unit, then it well may be that the landlord says, you know what, hold on to your rent, let's wait till the unit is fixed, and then we can pick up there. But again, it's always best that we recommend everyone have that conversation, make sure that you know what the landlord's understanding and intentions are, and also what the tenant's intentions and expectations are as well, because when people, for example, don't pay rent, there's always the risk that a landlord could file an unlawful detainer case for the tenant's failure to pay. So making sure that there's communication will be super important. If you have paid your rent and your landlord refuses to pay for a hotel, then ultimately, you are unfortunately left without the option of the landlord covering it, so you'll either have to pay it for yourself, or there are vouchers that have been provided by the county to help people with alternative housing. What we always recommend is that if that is your scenario, then keep your receipts, keep any receipts for hotels, food, things like that. And one of the options that might be available to you is to ask the landlord to either reimburse you for these costs, and or you can potentially bring a small claims action against them to recover any amounts that you are out of pocket. One of the important things to keep in mind is renter's insurance. If you have renter's insurance, sometimes they will pay for the alternative housing accommodation, so a hotel, things like that. So if you do have renter's insurance, very important to see what your policy is, and again, make sure that landlords and tenants are communicating with each other and understand what the expectation is, whether the tenant should or should not be paying rent if they have insurance. So another question we get asked pretty often is, do I still have to pay my rent if I'm out of the home while repairs are being done? So the short answer is probably. The ban doesn't absolve you of your ability to pay rent. And again, that's one of the things that, it's gonna be a it depends situation. Because again, like we mentioned, one could have renter's insurance, or there could be an agreement that the landlord, has worked out with the tenant. So we always recommend, like I say, making sure that you have that transparency in between landlord-tenant, make sure that everybody knows what the intentions and expectations are, and if those expectations are not in compliance with the law, then that's certainly a situation where we would recommend reaching out to a private attorney and or an organization that can give you some counsel and advice. All right, so as with anything, there are always exceptions and exemptions. So are there exceptions to the eviction ban? The short answer is yes. There are still certain scenarios where a landlord can evict someone even if they've suffered economic loss and they're living in a flood-affected area. The landlord is required to show what we refer to as just cause in order to be able to still evict someone under those circumstances. So what is just cause? Ultimately, the way that we break it down is a sanctioned or an allowable eviction. It's reasons that have been identified that the court will permit evictions to go forward. So under the ordinance, to establish just cause to evict, there has to be a showing that there is an imminent health or safety threat, and that usually exists when the tenant either does or does not do something that creates a threat to someone's health or safety. And of course, it can't just be a blanket statement, oh, this person is an imminent health or safety threat. We also have to take into account, is there a public health or safety risk? And are there any other remedies that are available to the landlord or to other tenants at the property, given the nature and the degree of the proposed risk that the tenant poses? What is not an imminent health and safety threat are things that the tenant either does or does not do in response to the flood and having to leave the unit for those reasons. That's not going to be seen as something that's an imminent health or safety risk because, again, the circumstances surrounding the flood are unique and they're not in any way, shape, or form typical or usual. So looking at what types of evictions can still occur under the imminent health or safety threat. So the types of evictions that can likely occur are some that we've identified as, a nuisance, waste, criminal activity at the property, or using the unit for unlawful purposes. The ban doesn't expressly list out the types of evictions that can still occur, but given the definition that they provided and the factors to consider as to whether something's an imminent health or safety threat, these are the types of evictions that we've identified that would likely be able to proceed under the right circumstances. So there have been people who already received termination notices when the moratorium went into effect. So one of the questions that we got asked pretty frequently is, if I already got served a notice, does the ban still protect me? And the answer is yes. The ordinance is retroactive, so that means that it goes into effect or went into effect on January 22nd, which is the day the flood happened. So it applies from January 22nd through the expiration of the ordinance, which I mentioned is going to be March 30th. Now that date is coming up in just a few days, and that's going to underscore some of the information I'm going to give you with respect to new laws that are coming into effect. All right, so another question that a lot of folks had is, if I'm in an active eviction case, meaning the legal case, does the eviction ban still protect me? And unfortunately, the answer is going to be, it depends. If your landlord filed the eviction case before January 22nd, then it is not likely that the ordinance is going to stop that case from going forward, even if you suffered economic loss and even if you live in a flood-affected area. And the reason why is because the moratorium in there says this shall not apply to any notices or cases that were initiated before January 22nd. If you get a notice before January 22nd, meaning we're not at the eviction, the legal stage, we're just at the notice stage, and you get it before the 22nd and it didn't expire until after the 22nd, it is possible that the eviction ban may be able to stop a case from proceeding. But again, it's one of those, it depends. It's not confirmed and guaranteed. So another question that people ask is, does the eviction ban protect against increases of rent? And the answer is yes. The eviction ban caps rent increases for eligible properties from the day that the flood began, which is January 22nd, through the end of the moratorium, which is March 30th of this year. And the moratorium is very clear, and it says, if a notice of rent increase was lawfully given to a tenant before January 22nd, then this does not apply, meaning any notices of rent increase given on January 21st or before are still valid. They're still able to proceed even with the eviction moratorium. But if you don't have that scenario and this ban applies to you, then essentially your rent cannot be increased by any amount greater than the consumer price index. We call that the CPI for the previous year. And so to make a long story short, the CPI is generally 5% plus the local CPI to get you the grand total of what the CPI is. So right now for local CPI, we have it at 5.3%. So under the ban, that would essentially prevent rents from being increased beyond 5.3% from January 22nd through the 30th of March. And the properties that are protected under here are all residential properties except those that are exempted under the statewide rent cap. And the reason that's important is because we're going to talk about the statewide rent cap in just a minute. And the properties that are exempted under that law are the same ones here. So we'll get into that in just a few minutes. A lot of folks ask, what are the consequences if a landlord violates my rights under the ordinance? So if they do, the options for a tenant are you can raise the violation as a defense if you are in an eviction lawsuit, or you can even file a lawsuit against the landlord yourself, asking for money damages, mental and emotional distress damages, injunctive relief, meaning asking the court to force the landlord to do or stop doing something, or any other relief that the court deems appropriate. So a lot of folks suffered damages, landlords and tenants alike, and one of the things that has been helpful in this process is that FEMA has approved funds for victims of the flood to have assistance. So we have the information here. If this applies to you, we absolutely recommend that you reach out sooner rather than later because there are deadlines and cutoffs for submitting FEMA applications. All right, so now we've talked about the flood and the moratorium. What I want to make sure everybody knows about and is kind of tracking are the changes in the state law. And so Senate Bill, or SB 567, is a law that's going to impact the entire state of California. And it goes into effect on April 1st of 2024, so in just about a week. And essentially what 567 does is it amends existing law. And that existing law right now governs termination of tenancies for what we refer to as no-fault just cause, and also rent cap. So the reason why it's important is because, as I mentioned, we just went through the flood moratorium, and that ends on March 30th. And this new law goes into effect on April 1st. Why is that important? Well, the reason why it's important is because SB 567 updates the law in 5 significant ways. So number 1, it increases the requirements to terminate a tenancy for owner-occupied move-in. It increases the requirements to terminate a tenancy for what we call substantial remodel. It provides enforcement mechanisms and remedies for just cause violations. It updates definitions for rent cap, and also provides enforcement mechanisms and remedies for rent cap violations. So the one that's really going to be important, and we're probably going to see an increase in these types of evictions soon, is the substantial remodel. So there are a lot of units that were damaged in the flood. And under the moratorium, landlords were not allowed to move forward trying to evict tenants for units that were impacted by the flood. But again, as we said, this ends on March 30th. And so there is a very real possibility that once the moratorium ends, we could see a spike in the number of evictions that are filed for the need to substantially remodel a property or a unit related to damage that it might have had from the flood. So it's really important for everyone to know what the new laws are, what the requirements are, because it's going to be very important as to what your rights may be. So in order to understand the new law of 567, we need to understand the law that it's updating and amending. So the existing law that I've been mentioning before is what we refer to as AB 1482, which is Assembly Bill 1482, and it's called the Tenant Protection Act of 2019. So what the Tenant Protection Act did is it, number one, established a rent cap statewide in California. That rent cap is essentially saying that a landlord cannot increase a rent for a tenant more than 5% plus the local CPI, or 10%, whichever is lower. And that's in a 12-month period. And so essentially in San Diego, the current CPI is over 10%. So the law as it stands right now for San Diego is that the maximum a rent can be increased under the TPA is 10%. Now, another thing that the Tenant Protection Act did was it established a requirement for just cause, meaning that in order for a landlord to be able to terminate someone's tenancy when the tenant has been living there for 12 months, they have to have a just cause, i.e. legitimate reason to do so. And as with everything, there are exclusions and exceptions, and we're going to get into those right now. So under 1482, which again is the current law, all units in California are covered by the rent cap and just cause, except. So we're not going to get into too much detail, but generally the properties that are accepted are single-family homes and condos, unless they're owned by a corporation, mobile homes, again, unless owned by a corporation or mobile home park, any units that are covered by local rent control ordinance that is lower than the annually calculated cap, meaning that your local ordinance is more protective than the statewide, then that would not apply, and your local ordinance would apply. Units that are constructed in the last 15 years, duplexes if the owner lives in one of the units, affordable housing subject to deed restriction. Important to note that even though Section 8 is considered affordable housing, this is not something that applies to Section 8 housing choice vouchers, meaning that they still get the protections of 1482. And we have had a written guidance from both HUD and the California Attorney General stating unequivocally that the Tenant Protection Act does apply to Section 8 housing choice vouchers. And the last category of properties that are exempted under 1482 are school-owned housing. So looking at the rent cap, some of the limitations that exist are a landlord can't increase the rent more than the 5% plus the local CPI in a 12-month period, or more than 10%, whichever is less. So if a landlord is raising rent, again, it has to be under that 10% in San Diego. Now, landlords can increase rent more than once, but again, it has to be, in San Diego at least, 2 times or less. And again, those two can't exceed 10% in a 12-month period. So when you're looking at calculating the rent increase, you always start with the lowest rent charged in that 12-month period. So let's say rent was increased the first time, you don't calculate the 10% off of the increased amount for the second one. It's always going to start at the lowest rent charge. That's what you use as your base. And also under AB 1482, we have what's referred to as vacancy decontrol, and that essentially means that if a landlord is starting a new tenancy, they can set the rent at whatever amount they want. They don't have to keep it at 10% of whatever the previous tenant was paying. So now we're going to talk about just cause under 1482. Essentially, a landlord has to have, like I mentioned, quote unquote, just cause to terminate a tenancy. And the way we characterize just cause is in two ways. It's either at fault or no fault. And when we're talking about fault, a lot of it refers to the tenant. And so, for example, something that would be considered an at fault is something that allegedly the tenant has done to bring about an eviction. And a no fault would be a scenario where a landlord has decided to terminate the tenancy through no fault of the tenant. So, when is a tenant entitled to just cause? When all the tenants have lived in the unit for at least 12 consecutive months, or if at least one tenant has lived in the unit for 24 months, they're protected by just cause. So if you have a tenant who's been living in a unit for 2-3 years and then they get a new roommate, that new roommate will get kind of grandfathered into this program. They will get the benefit and protection of just cause because at least one person living there has been there for 24 months or more. So looking at fault just cause, the legislature has identified these reasons as acceptable reasons that a landlord can evict a tenant for quote unquote at fault just cause, i.e. something that the tenant has done to bring this about. So some of the more common ones that we see are non-payment of rent, criminal activity, illegal subletting, not letting the landlord into the unit, and things like that. For no fault just cause, generally this can only be used if the tenant is month to month or at the expiration of a lease. But there are 4 acceptable reasons that the legislature has identified as reasons a landlord can evict, even though the tenant hasn't done anything to bring this about. And so those reasons are, number 1, the owner intends to occupy the unit and move back in. 2, they want to withdraw the unit from the rental market, meaning they no longer want to be in the rental business for this property. 3, the owner is complying with a government order, a court order, or a local ordinance that requires the unit to be vacant. Or 4, the owner intends to demolish or substantially remodel the unit. So of note, we're going to get into the changes of 567 soon, but SB 567 specifically touches on the first issue and also the 4th. So owner intent to occupy and also demolish or substantially remodel. So earlier we went over some of the exempted properties under AB 1482, and those apply to both just cause and the rent cap. But for just cause, there are even more properties that are also exempted. And so those properties are listed out here. Those are housing for local nonprofit hospitals, religious care facilities, or the elderly, transient and tourist hotel occupancies, housing where the tenant shares a bathroom or kitchen facility with the owner and it's the owner's primary residence or their main home, single-family owner-occupied residence where the owner rents or leases no more than 2 units or bedrooms, ADUs, junior ADUs, and if the government passes a stronger just cause ordinance. So for example, both the cities of Chula Vista and the city of San Diego have stronger just cause ordinances at the local level. So that means that they are not required to follow the specific rules of 1482 because the local ordinances are more protective. So the one that is more protective is going to govern. All right, so relocation assistance is required for no fault termination of tenancy. And what this is essentially considering the fact that a tenant, has not done anything to bring this about and the landlord is making this determination to terminate the tenancy, the legislature has set forth that the landlord has to provide relocation assistance to help the tenant in this type of situation. And so it's required for terminations that are quote unquote no fault. So it's not required for the at-fault reasons. And the amount that's provided is equal to 1 month of rent, and that has to be paid within 15 days of serving that no-fault notice to terminate the tenancy. So the owner has an option of either making a direct payment or they can choose to waive the last month of rent. And if they choose to waive that last month of rent, it has to be in writing and it has to say exactly how much is being waived. And if a local law requires more than 1 month of rent be provided as relocation assistance, then again, the local law applies because it would be more protective. So now we've got through 1482, we know what the law is at the moment, and so using that as a foundation, we're going to look at what Senate Bill 567 is doing, what updates it's providing. And it's important to know that the changes that we're bringing about in Senate Bill 567 are also being incorporated into the local ordinances as well. So that would be the City of San Diego's Tenant Protection Ordinance, as well as that one from Chula Vista. So we're going to go through 567, and again, like I mentioned, there's 5 ways that it primarily updates AB 1482. So we're going to just jump right in. The first way that it significantly updates AB 1482 is when we talk about owner-occupied move-in for those no-fault just causes that we were talking about. So for the owner-occupied move-in, what SB 567 does is it specifies that an owner or their spouse, domestic partner, children, grandchildren, parents, or grandparents have to occupy the unit as their primary residence for a minimum of 12 continuous months after moving in. So the only people that can qualify, or the quote-unquote qualifying family members, are going to be either the owner or those listed family members that you see here on the slide. Anyone that does not fall into that category is not going to be permitted or considered a authorized family member under this particular section of 567. And again, what 567 does is it makes clear that they have to live in this unit as their primary residence, and they have to live there for a minimum of 12 continuous months. So that was not in AB 1482, and these requirements make it very clear what the expectation is going to be for this particular type of no-fault reason to evict. So in addition to that, the intended occupant has to move into the unit within 90 days of the tenant vacating. So as soon as the tenant moves out, the person, whether it be the owner or their qualifying family member, has to move in within 90 days. So looking at the type of notice, when we're looking at notice requirements for this type of termination, it has to be in writing, and the notice has to have the names and relationship to the owner of the intended occupant. So if it's the owner, it has to say, I, the owner, am moving back into this property. If it's a qualifying family member, they have to give that person's name and the relationship to the owner. Additionally, there has to be a notification to the tenant in that notice that the tenant can request proof that the intended occupant is actually the owner or a qualifying family member. That proof can be provided at request by either a public or non-public document. It'll be at the owner's discretion, but it is not a type of proof that the landlord is required to give automatically. It is only required to be given upon request. If the intended occupant does not use the premises as their primary residence for 12 months or fails to move within 90 days of the tenant vacating, then the owner shall, meaning they must, offer the unit to the tenant who vacated at the same rent and the same lease terms that were in effect at the time that the tenant vacated. So one of the important things to note here is that it has to be offered at the lawful rent that was in effect when the notice was given. So like I mentioned, under the Tenant Protection Act, we do have the statewide rent cap. So if a tenant was paying rent at the time of the termination and that rent amount did not comply with the Tenant Protection Act and the rent cap, then that would be considered an unlawful rent. So it has to be calculated at the lawful rent that was in effect when the notice was given. In addition, an owner shall, meaning an owner must, reimburse the tenant for reasonable moving expenses that were incurred in excess of any relocation assistance that was paid to the tenant in connection with the notice. So as we mentioned, a landlord has a requirement to make that relocation payment or waive the rent, which will be either paid in 15 days or waived as the last month of rent. So if the tenant's moving expenses were more than what was waived or more than the payment given, then the landlord has to reimburse for that difference. Important to note that if the intended occupant does move into the unit within 90 days, but they die before having lived there for 12 continuous months, that is not going to be deemed failing to comply or being a material violation by the owner. So one of the things that 567 did is it created some more specific definitions, and so it clearly defines who an intended occupant is. And it also gives a little bit more detail as to who is a owner. And so one of the important things to note is that they really made an effort to ensure that an owner is someone who is a natural person, meaning a living, breathing person and not a corporation or an entity. So we see here some of the definitions that were given is a natural person that has at least a 25% recorded ownership interest in the property. Meaning that they have to have at least that percentage or more. Also, an owner is considered a natural person who has any recorded ownership interest if the whole property, the recorded ownership is divided amongst people who are related to each other. So let's say that a property is owned by a group of siblings and there happens to be so many of them that one person's recorded interest is not 25%, it's less. As long as those people are related, that would still qualify under this definition. So a few other definitions. Again, we have here the definition for a natural person and also other definitions that are included that were not in the Tenant Protection Act are definitions of a family trust and beneficial owner. So the next way that 567 updated the Tenant Protection Act is with respect to the cause for demolishing or substantially remodeling a unit. So what SB 567 does is it defines what a substantial remodel is. That wasn't something that we had clearly in the first iteration of 1482. So it defines substantial remodel as either of the following, meaning that these things cannot be done reasonably in a safe manner that allows the tenant to keep living at that unit, but instead requires them to move for at least 30 consecutive days. So it's either replacing or substantial modification of a structural, electrical, plumbing, or mechanical system, and that modification has to require a permit from a government agency. The second permissible reason is abating hazardous materials, such as lead-based paint, mold, asbestos, and that's in accordance with federal, state, and local laws. What SB 567 also does is it defines what is not a substantial remodel. So cosmetic improvements are not considered substantial remodel on their own. So things like painting, decorating, minor repairs, that's what considered cosmetic and not substantial under the statute. Let's see here. It also includes any work that can be performed safely without having the tenant to vacate. So again, if the tenant can stay there and it's not in violation of any health, safety, or habitability laws, although it may be inconvenient, they are not required to vacate. So an important aspect that was also included in 567 is that a tenant isn't required to vacate the unit on any days where they could actually continue living in the unit without violating these codes and laws. And the reason why that's important to note is, let's say, for example, that a repair is being done and it would only have the tenant out for 25 days. That doesn't meet the threshold of the 30 consecutive days that's under the statute. But it's very possible that there are cosmetic improvements that have to be done after. And so it's important for tenants to know that they do not have to be out for those cosmetic improvements, even if, let's say, a landlord says, well, we've done these, but we also need to, do some painting, some decorating, and that's going to take another week. That could potentially put us over that 30-day threshold. So this is just important for tenants and landlords to know as to what the requirements are under the statute. So when we're looking at a notice that a landlord gives for either demolishing or substantially remodeling a property, it has to be in writing and it has to have the following. So number one, we have to have a statement that tells the tenant that the owner is intending to demolish or substantially remodel the unit. And it also has to have this specific statement, meaning this exact language that you see here in the quotes. And without reading the whole thing, what this statement does is it lets the tenant know what their rights are in terms of if the unit does not go through with the remodel as indicated in the notice, or if it doesn't actually get demolished, it lets the tenant know that they have an opportunity to re-rent the unit with the same terms and the same rental amount that they had prior, and additionally lets them know what their duties are in terms of notifying the landlord that they do want to re-rent the unit and what information they have to provide the landlord with if they do choose to exercise that option. Additionally, another requirement for the notice is that it has to describe the remodel that's going to be completed and approximately how long it's going to take. Or if the property is being demolished, they have to give, when the expected date is by when the property will be demolished. And in addition to those two things, which is either of the definitions, you also have to have one of the following. So you need to have a copy of the permit or permits that are required to undertake the remodel or demolition. And if you are giving the notice because there is an abatement of hazardous materials, then ultimately you have to provide a copy of a contract that you have as an owner showing that the abatement is going to take place and generally what kind of work is going to be done. And so that's for situations where there is no permit required, and that would likely only come up in the situation of abating hazardous materials. In addition, you also have to have a notice that if the tenant is interested in reoccupying the unit after the remodel is done, the tenant has to let the owner know that they're interested in doing that and also give the owner their address, phone number, and email. It's important to note that landlords are not obligated to re-rent the unit to the tenant once a substantial remodel is done, but this does require them to at least let the tenant know that if they're interested, they should express that interest. So another thing that SB 567 did in terms of updating existing law is it created more remedies for just cause violations. And so if a landlord doesn't comply with these provisions that we just went over, then it renders any notice to terminate the tenancy void. And so a landlord who tries to recover possession of a rental unit in violation of the law shall be liable, meaning they will be liable to the tenant in a civil action for all of the following. So that would include actual damages, reasonable attorney's fees and costs to be determined by the court, and potentially up to 3 times actual damages if there is a showing that the owner acted willfully with oppression, fraud, or malice. Punitive damages are also something that may be awarded as well. So the things that I just went over are considered what we call a private right, but importantly what 567 does is it also gives a public right and a public remedy. And that would be through allowing the state attorney general, the city attorney, or county council for wherever the unit is located to seek injunctive relief. And as I mentioned before, that's either a requirement that the landlord do or stop doing something. So we have both private and public rights of action in terms of the remedies under this new law. So in terms of the properties that are exempted or excluded, there was only one minor change to that, and that would be the exception for duplexes. So what they did is they have changed the language. It no longer specifically says duplexes. They have changed it to be a property containing 2 separate dwelling units within a single structure. And essentially that gives a more broad latitude for properties to fall under that category. Doesn't necessarily have to fall under the traditional definition or understanding of what a duplex is. Okay, so another thing that SB 567 did is it has some updates to the rent cap. Now, it's important to note that there are no changes to the percentages of the rent cap. It is still capped at 10%, or your 5% and local CPI. But what 567 did is it created and updated some definitions, and it also detailed what the remedies are if there is a violation of the rent cap. And so this applies to all rent increases that occurred on or after March 15th of 2019. And mobile homes, it applies February 18th of 2021 or after. And these new remedies and definitions, as I mentioned, go into effect when the statute does, which is again April 1st. And they are good through January 1st of 2030 unless they are extended. So some of the definitions, and I'm not going to get into them in detail here, but some of the definitions that were added are definitions for consumer price index for all urban consumers and all items, a detailed definition of owner, and a detailed definition of percentage change in the cost of living. Now, coming from someone who has gone through the statute and parsed this out, the prior version under 1482 was not always the easiest to understand and use as a basis to calculate what the CPI is. So a great thing about 567 and the changes they made to the definitions are they make it a lot easier to understand where you find the numbers, who is hosting the numbers, and what the actual percentage increase is under the rent cap law. So another thing that I mentioned is the update for rent cap provided and created some remedies if there is a violation. So an owner who demands, accepts, receives, or retains any payment in excess of the maximum rent allowed by this section shall, meaning they will, be liable to a tenant in a civil action for all of the following. So again, we talk about injunctive relief, forcing the landlord to do or stop doing something, damages in the amount by which any payment demanded, accepted, received, or retained exceeds the maximum allowable rent, reasonable attorney's fees and costs, again, at the court's discretion, and up to 3 times the amount by which any payment demanded, accepted, received, or retained exceeds the maximum allowable rent if we can show that the owner acted willfully with oppression, fraud, or malice. And again, punitive damages are also available. The interesting thing about this definition here and this particular remedy is that the way it's phrased, it's an owner who demands, accepts, receives, or retains. So it's not even that the tenant has to actually pay the amount. If an owner so much as demands it, that qualifies under this definition. And so that would entitle a tenant to the remedies that are carved out under this particular section of the statute. So it's important to know, in essence, making sure that, whether you're a landlord or a tenant, that you understand what your limitations are and what your rights are before moving forward. So again, as with the just cause, we have here also the public right and the public remedy, where again, we have the Attorney General, City Attorney, or County Council able to seek injunctive relief based on any violations of the rent cap. So one of the great things to note here in 567 is that while we have the public right, it specifically carves out in the statute that any actions for injunctive relief shall be presumed that the tenant suffered irreparable harm through violation of this section. So one of the things that is often required to be proved as part of a case for injunctive relief is showing that someone suffered irreparable harm. And so by specifically carving that out and stating it in the statute, that's something that is going to make it easier for tenants to be able to exercise and use this particular remedy. And importantly, there is a statute of limitations. So if a tenant does choose to file a lawsuit under this particular section, the statute of limitations is going to be 3 years from the date on which the cause of action accrued. And that usually is going to be when they receive that notice of rent increase. So, we went over a lot of information, and there may be some questions that folks have. So we want to let you know that if you have any questions, please feel free to reach out to us. We are always willing to take in your questions and hopefully give you information. And should you have any other questions aside from that, please don't hesitate to reach out. So thank you all for your time, and we look forward to hopefully presenting again soon.